Good afternoon, Your Honor. Laura KOSCKI and Pro Per.
Good afternoon, Your Honor. Kim Posen of Latham Watkins, counsel for the trust and the debtors.
Ms. KOSCKI, I am a little bit confused by your situation here. Let me explain to you why. As I recall, and as the papers seem to indicate, long time ago, you were in my court, and we did a claims estimation, and we estimated your claim at a certain number, which required the debtor to set up a reserve in the bankruptcy side of the case for that claims estimation amount. Was, I think, $5 million and some odd dollars, if I'm not mistaken, close to $6 million bucks. And I said, that's what I figured you'd maybe do best out of your $240 million claim. Well, I may be right, I may be wrong. So far, I have no idea whether I'm right or wrong. And then what I also did is, because this involved issues of workman's comp claims, it involved issues of hostile workforce claims, it involved issues, I think, of wrongful termination because you were doing some union complaining about drivers. I'm just going off my memory, a whole lot of that stuff out there. I said, hey, that's not for me to try. You're going to get a jury trial, go to district court. And I sent you to district court, which meant we'll make them hold the money. You get your case resolved in district court. Now, you had a claim. That is your claim.
Correct.
And whatever happens in district court is the claim. Now, all of a sudden, I get you filing an amendment to the claim that basically reasserts everything that it was before, saying, well, I want to restart my claim again, even though I said, wait a minute, I set aside almost $6 million for you. Go to district court. Whatever they rule will be your claim. If it's for more, then I set aside $5 million to protect your claim. If it's for less, then, hey, they'll give the money to other creditors. Last I heard from the papers that were now filed, you got a problem in district court. Apparently your case was dismissed. You got it up on appeal. Well, you don't go file a new claim here. You resolve your problem in district court. Your claim is still on the books.
Okay.
Okay? It's on the books subject to what the district court rules on. If you ultimately lose on your claim in district court, the $5 million I've had them hold on reserve for you goes into the coffers for everyone else. If you win in district court, then it still sits around there to be distributed once you get a final number. But until then, there's no reason to file another claim. You're gunking up the books.
Your Honor, I was really trying to get it from unsecured to secured.
But you're not a secured. You will never be a secured creditor. Your claim is related to, your entire claim is related to alleged wrongdoings that they committed against you. Okay. That's a claim for damages.
Okay, how about priority? Will it move to a priority?
No.
No?
Because the only priority claim that you would have ever had, the only claim for priority rights that you had, and that would be separate from this reserve claim, would be up to $4,650 at the time of the bankruptcy, would be up to $4,650, less whatever you were paid for unpaid wages, and this is under Section 507A, now A4, A5, Section 507A3, A4 then, up to $4,650, and this is for any unpaid wages, due and owing within 90 days of the bankruptcy, unpaid sick leave, unpaid vacation time, maybe under 507A4, A5, I've got this one under submission, maybe retirement benefits, maybe not. That's going to be an interesting issue that we're dealing with Aetna. And those would be your claims. Priority is a very narrow wage claim priority. You're not an administrative creditor. You don't qualify in that category. You're not the IRS. Don't qualify in that category. You're just an aggrieved employee.
Okay.
All employees have a very narrow right of claims.
Right.
That's priority.
According to the case citations that I have here, I'd like to submit to the court. If they didn't have workman's comp, then it would be up to the judge's discretion whether I could lien against the real estate. And then there was this priority.
Well, the United States Supreme Court has just answered that question in June of this year.
Okay.
Okay. Justice Ginsburg for the majority, which is why my case is on hold. I was getting ready to rule until she made her decision, ruled that workman's comp is not a priority claim.
Okay.
So the workman's comp carrier who isn't paid can't get a priority claim, nor can the employees get a claim.
Okay.
But anyway, even if it was, even let's say you suffered a workman's comp injury, an actual injury that hadn't been compensated. And let's assume Justice Ginsburg said injuries related to workers' comp qualify under the additional retirement benefits or other benefits negotiated by the employee, which states rule workman's comp doesn't qualify for. Let's assume it was the reverse. Maximum ceiling by law for both categories combined, $4,650. Now, you could get in a pot with all the others if you were under 507A5 now, but, you know, if I let the retirees in, that pot's going to be nothing then some, because the pot is you would share pro rata with all these other people. At this point, we've taken such a liberal approach with the employees. The WARN Act damages for all 18,000 employees, the lost wages for all 18,000 employees, lost sick leave for all 18,000 employees. Most of the employees have eaten up the full amount of their $4,650. According to their paperwork, if somehow you had a residual priority claim, they've already paid you under the traditional priority claims. I think they said...
yes, they have.
They paid you all but a couple hundred of it. I'm just looking for the number.
All but $994.64, Your Honor.
Okay. So that, you've been dealt with just like any other employee. And because if the rest of your claim for priority to say, well, will at least the $994.64 be a priority? If it's for workman's comp medical benefits instead of health insurance benefits, health insurance would reach a priority as an employee, not as a retiree. Well, maybe as a retiree, that's up to my decision to make. We're still working on that one. But if you were employed at the time and you had medical bills that remained unpaid, then you could modify your claim, if you wish, not for $240 million. You want to modify to say there was a certain amount of my medical bills, out-of-pocket medical bills incurred within the 90 days while I was employed, or shortly after I was terminated, that never got paid. And they're over and above, and they haven't been paid because everything else has been paid. You could maximize your claim to $944.64 as a priority. But the way you've drafted your claim, I have no idea what the heck you're talking about.
Correct.
Because you put it all together in this great big lump sum. If you want to say that you wish to amend your claim that's been approved to include an increased priority claim for $994.64 based upon unpaid, and attach maybe some of the receipts.
Okay.
So they could, because they'll look at it.
Okay.
They don't want to spend $2,000 in attorney's fees to argue over $994 a priority, which you would automatically be allowed as a general unsecured. The difference is priority will be paid 100%, unsecureds will get 12% maybe. And if you have legitimate unpaid bills relating to health care that was covered by their plan, and you want to put in a priority claim for that portion so you can try and get the extra $994, don't go for $240 million.
Right.
Don't tell me what's going on in the district court. I only want to know the end result, not what's going on in between it. If you lose, then your claim will go away, the big one, the $240 million one. But, you know, until that matter is done, my only interest in you at this point, if any, other than waiting for what the district court does, is if you wish to modify your overall claim to say a portion of my claim related to blah, priority, and my priority claim, here's a copy of the bills. Don't tell me about your wrongful termination. Don't tell me about this hostile workforce. Don't tell me about your emotional distress. None of that's covered. The code is very, very clear. It has to be unpaid wages. No, if it's unpaid wages, remember they paid you almost $3,500 of it, $3,600 of it. So if they paid your wages up $3,600, don't argue that again. You can't get paid twice on that. Can't get paid on any unpaid sick leave. Can't get paid on any unpaid vacation pay if it's already been paid. But if you say over and above what they paid me, which was this, they still owe me the balance of the $994.64 because, and you lay it out, then they'll take a hard look at it. And if the data's there, they'll either not object to it, or they'll make a decision whether they want to spend the time to object to it. But the way your claim is structured is denied without prejudice, okay?
Your Honor, I appreciate you explaining that to me. I was wondering, too, though, can you explain the non-dischargeable? It still is up to federal court as far as...
A non-dischargeable debt is only against individuals. It's not against a corporation. Corporations don't get a discharge. They just go to heaven. They're gone. Their paperwork is gone. When the company is no longer